Welcome again, everyone, to U-Visa Certifications and Special Immigrant Juvenile Status, the Judge's Role, held today on Friday, November 30th, 2018. Today's webcast is 75 minutes in length, and your presenters are the Honorable Ramona Gonzalez and Professor Leslie Orloff. Judge Dean Lum will be introducing our faculty today. Judge Dean Lum, Judge Lum was appointed to the King County Superior Court in Seattle, Washington in 1998 by Governor Gary Locke and is currently assigned to the Criminal Department. He previously served on the court's civil and juvenile calendar and was the court's chief civil judge and chief judge at the Malang Regional Justice Center in Kent. He currently serves on the ABA Commission on Immigration, the President's Minority Community Advisory Committee for the University of Washington, and the Board of Washington State Superior Court Judges Association. Judge Lum joined NJC faculty in 2015. And without further delay, Judge, I will hand it over to you. Thank you.
Good afternoon. I'm Judge Dean Lum from the King County Superior Court in Seattle, Washington. As Danielle said, I'm a member of the ABA Commission on Immigration and the ABA's Working Group on Unaccompanied Minors. Some thank yous. First to the NJC for hosting this webinar, also to the State Justice Institute who sponsored this program, and to the entities that developed this program, the National Council of Juvenile and Family Court Judges, and the National Immigrant Women's Advocacy Project. Today's webinar could not be more timely or topical. It doesn't matter what state you're from or the size of your jurisdiction. The reality is that state court judges, us, are increasingly being asked to make decisions which affect immigration status generally, and more particularly are being asked to rule on U-Visa certifications and special immigrant juvenile status petitions, the subjects of today's webinar. Today, we have two fantastic presenters. Their complete bios are in your materials, but first we have Judge Ramona Gonzalez, who served as a Wisconsin Circuit Court judge since 1995. She's long been a national leader on family and juvenile court issues and is currently the president-elect of the NCJCJ. She'll assume the presidency in July of 2019. Both she and our next presenter have extensive nationwide experience training state judges and lawyers on U-Visa certifications and SIJS issues. Next, we have Professor Leslie Orloff, who is an adjunct professor and director of the National Women's Advocacy Project at the American University Washington College of Law. She has a long and distinguished history of protecting women, children, survivors, and immigrants from trafficking and violence. With that, I'll turn the floor over to Judge Gonzalez.
Hello, everyone, and welcome. We are ready for a really quick hour and so 10 minutes to go by. So first of all, let's find out where everybody's from. If you could click your little arrows and show me your locations. Danielle, let's see here where everybody's come from.
Thank you, everyone. And just a really quick reminder, your arrow tool, if you look to the upper left, just above the slide we're looking at now, to the far left, you'll see a little gray arrow. You click on that and then click anywhere on the screen. Your answer will be indicated.
And while we're doing that, Leslie, tell us about some other information that would be helpful.
Yes, so this training that we're doing today was developed with a grant funding from the W.K. Kellogg Foundation awarded to NUAC, Washington College of Law, the Michigan State University, and then we're partnering with a number of judicial education, state-based judicial education programs, including the Michigan Judicial Institute, the Mississippi Judicial College, the New Mexico Judicial Education Center, and the Missouri Office of State Court Administrators. And we were in the process of formalizing an agreement also with the Office of State Court Administrator for the state of Florida. And so we're doing, this is a portion of the trainings we've been doing nationally and in each of these states for state court judges about the intersection of state, the issues that state family courts in particularly encounter, and immigration law.
So it looks like we are all from all parts of the country, and welcome everyone. As we begin, let's think about what we hope to accomplish in the next hour and such. By the time we are finished, it is our hope that you will be better able to employ best practices when issuing state court findings in cases of abuse, abandoned, or neglected children who are eligible for Special Immigrant Juvenile Status. Also, you'll be better able to exercise discretion to sign those U-Visa certifications in not just family courts, but in criminal protection orders, custody orders, and other civil court proceedings, and make our orders and findings on probable cause to believe that the immigrant victim has suffered a U-Visa listed criminal activity. And really, the bulk of what we hope you take away from this is that you'll be able to identify the range of topics and materials which the State Justice Institute has funded and developed the training materials that assist state court judges in adjudicating cases involving the care, custody, protection, and well-being of immigrant children and immigrant crime victims. Obviously, in an hour and 10 or 15 minutes, Leslie and I are not going to tell you everything you need to know. So being able to understand where you can go to get more information is really important. And I think we'll give Leslie the ball. Go ahead, Leslie.
Thank you. So we're going to start by talking about just some basic immigrant demographics. Wherever you are in the country, roughly, I mean, some states are more than others, but about 13.5% of the U.S. population are foreign-born. Almost half of those are naturalized citizens. Another third are, a little under a third, are lawful permanent residents. And then there are a number of people that are in either temporary work-related visas or they're undocumented. There's a variety of different statuses. And when we talk about SIJS and U visas and the other forms of immigration relief that may be available to crime victims, it's those categories. It essentially helps anybody who is not already a naturalized citizen or a lawful permanent resident. Importantly for this webinar, over a quarter of children under the age of 6 and under the age of 18 are living in mixed immigrant status families where they have at least one or more immigrant parents, and the number of children in those, the proportion of children in those families, a very high proportion of them are U.S. citizens. The other thing that's important to understand is that about 85% of immigrant families have mixed statuses where one person may have citizenship and another may not, and that 18%, although we're not talking about it here, it's another topic we do cover, 18% of people in the U.S. over the age of 5 speak another language other than English at home.
So
go ahead.
I think what we're talking about then is we're talking about victims of crimes and whether or not they're eligible for this relief. I call this alphabet soup. This chart combines all of the available relief for immigrant victims of crimes. And Leslie, sometimes it's really hard to describe all of this alphabet soup in the ways, because why does Congress keep using all of these acronyms for us?
Well, I think part of it has to, immigration law is like that. We spend a lot of time trying to break it down, but the easiest way to think about this is that any time you're sitting in any kind of a court case that involves a crime victim, and these are mostly violent crimes, so all of the domestic violence and child abuse-related crimes, sexual assault-related crimes, hostage-taking, kidnapping, felonious assault, blackmail, and things like that, or any time you are working in a case where there's been child abuse, neglect, or abandonment, likely if there's somebody in your court who is not an immigrant, doesn't have legal status or lawful permanent residency, it is very likely that person has a path even though they may not know it. And so it's really important to understand that over the last 3 decades, or 2.5 decades, there have been lots of different forms of immigration relief developed to help crime victims.
So whether we're talking VAWA or T visas or U visas, it really does come down to whether or not they are a victim of one of those crimes. So let's do a little participation by our audience now. So in what percentage of the cases you hear involving immigrants has a litigant, a child, or a child's parent been a victim of one of these crimes? And you go, I think Danielle has already told us how to vote, so to speak, so let's see how we go.
Thank you, everyone.
Pull over to the right, and then you just click the box and hit submit.
Not with the arrows, just the clicking on the
right-hand side under the poll questions.
Right.
Is the little circles.
You hit the little circle, and then you hit submit.
Yeah.
Thank you, everyone. Votes are coming in, and it will be over on the right-hand side of your screen where you can make your answer selection and then press submit when you're finished. I'll go ahead and close that poll here in just a moment. Sometimes it takes WebEx a minute to generate responses or a few seconds, so I'm going to tell our faculty, it looks like the majority have selected C, 35%. I'll close that poll.
Great. So that means, that you're often seeing these, if not always, but you're often and aware of it. So that's really important. So what we're going to be talking about today, do I have control back? I do. This is a handy tool that was developed by the Department of Homeland Security, and what it does is it provides an overview of the forms of immigration relief immigrant victims are eligible to receive. Are you all seeing the shield on the page, or did I not switch it? Are you seeing it?
Yes.
Gonzalez? Okay.
Yes.
Okay, great. And so what I want to do is just talk a little bit about there are various different forms of relief. The alphabet soup isn't really what matters. The most important thing to do is to recognize that in addition, we're going to be talking about the U visa in detail today. But in addition to that, many people who come before the court would be eligible for something called the Violence Against Women Act, or VAWA, self-petitioning. Those are generally cases where there's abuse, where you have a marriage, and the abuser is a U.S. citizen or lawful permanent resident who's abusing his spouse or her spouse or children. So those are cases where the person perpetrating the abuse is a citizen or lawful permanent resident, and the victim is either a spouse or a child, or in the case of an over 21-year-old perpetrator, son or daughter, a citizen. And so those are cases we're not going to talk about a lot today, but that's one of the forms of immigration relief. The other thing that we're not going to spend a lot of time on, but you should be aware of, is that victims of human trafficking, either sex trafficking or labor trafficking for both adults and children, could also be, who you might identify in your courts, could also be eligible for a T visa. And the court may be the first entity that person actually has language access to, who is in a position to provide know your rights public information about these forms of immigration relief. And that protection from that when people pursue, when victims and children pursue immigration relief, what comes with them is protection from deportation, access to work authorization. In many states, the work authorization access triggers access to a driver's license. There are wait times for access to work authorization once you file one of these cases, from between 8 months to over 4 years. And that, depending on the state, and we have lots of tools for judges and courts on these, what also comes with is access to federal and state-funded public benefits. And which public benefits an immigrant gets, it varies by state and varies by type of case. We have state-by-state charts available to you on our website, and a cool map tool that my undergrad students have built this summer that will help you with that. And then finally, what also comes is what's called VAWA confidentiality protection, which is the only form of legal protection or protection in federal law from deportation for anyone. And basically it says that the Department of Homeland Security, to remove somebody or to rule against them in an immigration case, can't rely on perpetrator-provided information.
So I think we can start thinking about how access to these legally available benefits would be of assistance to those who are trying to access justice in our family courts. Can anyone think of a couple of ways that that might be? Sending it out to the poll question, and if you want to just...
I'm looking for any raised hands right now, Judge. I was just scrolling through, and I don't see any raised hands and any messages in the chat tool yet.
Okay, well, I think maybe we'll get back to this as we continue with our time. But if you're thinking about in courts, those who have to have economic needs met, think about how having this legally available immigration status might be assistance to them to get some of those benefits. What do you think, Leslie?
Well, I think it can be very helpful, and in fact, starting the process early can have tremendous benefits for not only the individual crime victim, but the community at large, so that we don't end up with a situation where a child who comes into court at age 5 who's eligible ages out before, they turn 18 before anybody figures out that they may have been eligible for immigration relief that they didn't qualify for. Similarly, access to U visas, for example, have a really important public safety protection. There have been cases where a victim of domestic violence developed a relationship with a local law enforcement officer who signed her U visa certification. She was the girlfriend of a gang member. There were police officers embedded in the gang that the gang learned about, and she went back and told the officers, and those officers would pull from the gang, and it saved their lives. So those kinds of things can be really important.
All right, I'm going to give you control back, Leslie, if you want to take the next slide.
That's great. So, and the other thing that's really important is that once victims begin to file for immigration relief, one of the things that we know, and this is 2013 data, and we've done this again in 2017, and the data is very similar, is that perpetrators of domestic violence, sexual assault, human trafficking, and child abuse are actively involved in trying to get their victims deported by calling immigration and trying to get them removed so that they cannot gain custody, they cannot win a protection order case, or they cannot participate in a criminal prosecution.
And Professor Orloff, we did have a question come in to the chat tool. And the question is, are there any government agencies providing assistance for the litigants to seek out and apply for immigration relief, or do we need to find private attorneys in our area?
So we have a tool, which I can post in a few minutes, funded by the Department of Justice, the Office of Violence Against Women, in which we've been able to identify people, programs all over the country that have gained through training and are involved in representing immigrant survivors of domestic violence, sexual assault, child abuse, and human trafficking in communities across the country. And in fact, the best referrals are to the programs that are at the community-based level, usually nonprofits, doing this work, because the lawyers around the country with the most expertise and the victim advocates and the most expertise in working with this population are generally not private immigration attorneys, and many private immigration attorneys don't have the expertise to do these cases. So I can make that directory link available in a few moments.
But I think we also need to understand that sometimes you just don't have those resources in rural areas. And right. at least some judges, I can name one for a fact, Judge Doug Johnson in Omaha, has taken it upon himself to appoint immigration judge or an immigration attorney for some of his juveniles in making that application, because he sees that as being in the best interest of the child.
And what's interesting, Judge Gonzalez, about that is any judge who decides to do that and wants to connect them with resources My agency receives national technical assistance funding from the Office of Violence Against Women, and we can support any attorney in any kind of a civil case, in particular family civil case, so that we can get them up to speed if you do appoint someone.
So that's something to think about, because again, that access to justice and being able to have an attorney is very, very important in these cases. Danielle, do we have any other questions, or should we move on?
No other questions at this point.
All right, we thought it might be helpful if we actually put some meat on the bones of this conversation. So we have a case scenario. Clara met Eduardo, a naturalized U.S. citizen, when he came back to his hometown to visit his family in El Salvador. Eduardo started dating Clara, who was raising her 9-year-old son, Miguel. And after Clara became pregnant and gave birth to a baby girl, Lupe, Eduardo decided to bring Clara, Miguel, and Lupe to the U.S. to live with him. When they arrived in the U.S., Eduardo took Clara, Miguel, and Lupe's passports and became physically and sexually abusive to Clara and abusive of Miguel, who tried to protect his mother from Eduardo's abuse. Eduardo also physically beat Lupe when he said she misbehaved, and within a year following their arrival in the U.S., Eduardo forced both Clara and Miguel to work for his family's business, never paid them for their labor, and one night when Miguel was 13 and Lupe was 5, Eduardo raged led to severe beatings with a belt of Miguel and Lupe. And when Clara intervened to protect the children, Eduardo strangled her until she passed out. Now, the neighbors called the police for help. Clara talked to the police when they arrived. The police arrested Eduardo for attempted murder and child abuse and took Clara to the hospital and placed the children in the care of the state. So, what forms of immigration relief would Clara qualify for? Based upon what you know, and you have a poll on the right-hand side. If you can just take your answer and hit submit.
And just 1 second, that poll will be up just momentarily, and here it is. It'll be over on the right now, as Judge Gonzalez said. And just be sure to click that submit button after you make your answer selection.
We'll take a few minutes.
Votes are coming in, and we'll close that out here momentarily. It looks like the majority, over 50%, have selected D, and everybody else has selected A. I'll go ahead and close that poll right now, and I apologize, there's another mild delay, so I'll share those results as soon as WebEx generates them. Thank you.
So it was a really long scenario, Leslie, but we tried to push everything in there. What do you think?
So those of you that said D are correct, and I'll walk you through why. So Clara qualifies for a VAWA self-petition as a victim of, because she was a victim of essentially domestic violence. Strangulation could be an aggravated felony. I mean, it could be but at least domestic violence and other crimes as well. And she cooperated with law enforcement by providing information. So that's absolutely true. She also qualifies for a self-petition as the parent of Lupe, who was a victim of abuse. And that would be true without regard to whether Lupe was born in the U.S. or abroad. And finally, because of the forced labor, being forced to work for a family business and not paid, she also could qualify for a T visa.
Okay, so if that was the situation for her, what forms of immigration relief would Lupe and Miguel qualify for? And if we bring up the next poll, while she's bringing up that poll, the first time I read that
to you, so you can think about what you'll check. Danielle, you're working on that?
Yes, thank you for your patience. Thank you, everyone. It'll be open just momentarily. We're passing the ball around a lot, so thank you, everyone, again.
This is the prior. Okay, we're still waiting. So the choices are both can VAWA self-petition, both can qualify for a U visa, Lupe qualifies for a T visa, or all of the above.
Okay. And
thank you, everyone.
The answers are coming in.
Yep, the poll is open, and so far we have a pretty even split again between B and D this time, with the majority selecting B. I'll go ahead and close that poll out. And
Great.
if you want to speak to the question as WebEx generates the results, I'll share those momentarily. Thank you.
So I think
the correct answer is B. The reason, Lupe, who is the child of child of Eduardo, can file a self-petition because he is the child of a U.S. citizen. If what's missing here is that Eduardo and Clara were never married. If Eduardo and Clara were married, making Eduardo the stepfather of Miguel, then Miguel could also self-petition. But here, since since Miguel can't self-petition, he would be a U visa applicant. And while Miguel, because of the forced labor, would qualify for a T visa, Lupe would not qualify for a T visa because there was no work, she wasn't involved in the work activities. So the correct answer is that Lupe would qualify either as a U visa, Lupe and Miguel would qualify both for U visas, but Lupe would also qualify for a VAWA self-petition, which is a much quicker process. It takes about, for a child of a U.S. citizen, it might take a year to get a VAWA self-petition approved, and to get lawful permanent residency based on that might take another year. A U visa could take 4 years to get initially approved, 11 years to wait for the visa, and even longer to get lawful permanent residency.
Okay, so now that we've completely confused everybody with alphabet soup, should we start with the U?
I think so.
All right, so we're going to start with our conversation with U visa certifications by judges. And this is sort of uncomfortable at times for judges to think that they are actually going to sign these certifications. But keep in mind that the certification is not you granting a visa. A U visa certification by a judge is simply taking a look at one step of the qualification process. So you're looking at whether you have before you a victim of a qualifying criminal activity. And that person is eligible if the criminal activity occurred in the United States or violated U.S. law. You also have to consider whether the victim possesses information about a crime. What we're looking for is an opportunity to have assistance in providing a safe community. And to do that, we encourage people to report crimes. So if the victim has been or is likely to be helpful in the detection of that investigation, prosecution, conviction, or sentencing of the offense, that also is part of the certification. And the victim has suffered substantial physical or mental abuse as a result of the victimization. So first of all, the first question is this person a victim of that qualifying crime? And if so, do they meet this criteria to be eligible?
And what's really interesting about this is, as to certification, the last bullet, the substantial physical or mental abuse, is not something that the certifier is asked to address. And you can address it on the form, but it's not mandatory. You can certify based on observing the victim's helpfulness in any kind of a criminal or civil case, and the victim later has to prove the substantial harm to win the U visa from the Department of Homeland Security.
Yeah, this is not a factual determination that you are making as a judge certifying these.
Next slide, please. Okay, so, and what's important is that helpfulness to the investigation or prosecution always means anything from detection through sentencing. Crime also always means criminal activity, and criminal activity was chosen by Congress because they wanted people to get access to the U visa as early as possible to improve their access to justice in both the family and civil court context, as well as in the criminal context. So these, again, this looks similar to that other slide. These are all the criminal activities covered by the U visa. What's most important to remember in terms of state court cases is, generally speaking, 75% of the criminal activities that we're discussing here are domestic violence, sexual assault, human trafficking related, or child abuse related. Other serious criminal activities are covered, but those make up the majority of the cases we see nationally. I'm going to give you back the ball, Judge Gonzalez.
Okay. Go to the next slide. So we went too far. All right. So why are we having this conversation? There are lots and lots of individuals who are in a position to certify that someone is being helpful in the process of prosecution or reporting crime. We're going to concentrate on this section that talks about the judges, magistrates, commissioners, and the such. We're talking about judicial officers who are sitting in a place to be able to look at the facts as they exist before us and make those findings. The types of criminal proceedings that these types of evidence can come in are very varied, and sometimes people get hung up on the fact that we're talking about crime victims. And so, Judge, isn't it true that you can only see these in criminal cases? And the answer is no, because many times while we are sitting in family court, we can tell from the facts and circumstances of that particular case that the individual who is the litigant that is appearing before us may in fact be the victim of a crime. So any kind of these types of proceedings may bring to mind cases in which you may be in a position to certify a U visa certification, and it has nothing to do with you sitting in criminal court at the time. So let me ask this question in this next poll. Why would victims seek U visa certification from a state court? Why you as opposed to all of those other agencies? Make your selection.
Thank you, everyone, and the poll should be open over on the right-hand side of your screen, and after you make your answer selection, be sure to click that submit button, just in case we had anybody jump on in the last 15 minutes, and I'll go ahead and close that poll now.
And the results are?
I'm going to share those results with you right now, and it looks like the majority chose D, all of the above. You should see those results on the right-hand side of your screen, Judge.
Thank you. So, Leslie, as an individual who has worked in the immigrant community most of your career, why is it that we are on the front lines of state court judges?
Well, it's because in many cases, the courts are going to have better language access, for example, than it might be available through the local police department or might be available through the local prosecutor's offices. So many times that it's once the victim shows up in court for a protection order that she's first getting an interpreter, particularly for victims who don't speak English or Spanish. The other thing is that there are ways people might access the justice system in the family law or the civil context where in a civil case you might be participating with the EEOC or made a complaint of sexual harassment when there was sexual violence or rape in the workplace, and that be coming up in a civil case, but there's no criminal prosecution. Or somebody may raise the child abuse or the domestic violence as part of their protection order request, or they're part of a custody case or a child welfare case. And so that these are people that may have no contact with the criminal justice system, only with the civil. And there's a resource I'll post in a few minutes in the chat that was made available by the Department of Homeland Security wrote, confirming that participating in the civil justice system, filing a case, showing up to testify, seeking an order is enough participation for a U visa, because the goal is to, again, improve access to justice, because one of the things we see when we look at crime victims who begin using the U visa, SIJS, follow self-petitions, et cetera, is that not only do they participate in that case, but those victims are more likely to call the police for help in the future, more likely to seek the assistance of state court judges and other kinds of cases once they start using the system and learn through their experience in the court system and the victim advocates and attorneys that are helping them access the court system, that this is a safe place and an option for them.
And I think it's important for judges to understand also that we may be the only game in town, right? They may, in fact, only have contact with our court system, but there's also a problem with information. How would they even know that they needed to come to you to get this kind of certification? And we can't tell them that from the bench, but we certainly can be judicial leaders in our communities to try and make sure that our social workers in our Department of Human Services have this information so that people have a sense that if they cooperate to prevent crime and to report crime, that there is this assistance available to them. It's really important for us to understand that we aren't, again, making the determination that someone is getting a visa. That is not our job. The USCIS only needs 3 things from us. That I believe the applicant is a victim of a qualifying criminal activity, that the victim had knowledge of the criminal activity, and that the victim was or is likely to be helpful in the detection, investigation, prosecution, and conviction or sentencing. So if we break that down, really, that is something that, those are findings that we can make in any of the cases that we have been talking about where you may be able to see this, in a civil case or a family case. And if you break it down to what we're talking about, the most important element, I think, Leslie, is when we talk about this helpfulness requirement.
Right, exactly. And the preamble to the U visa regulations make it clear that when judges certify, they're certifying based on detection. Did evidence come into their case? Did they review a pleading that they believe is credible? Did they hear testimony? Any of that is a way judges detect. In addition, they might be certifying based in criminal context on conviction or sentencing. But most of this we're talking about are ways that, you know, things judges learn and the kinds of findings judges make. And most of the time, U visa certification, the vast majority of time, is happening after the court has already ruled. So you're doing it based on your own findings.
So if you're looking at family or civil cases, these are some examples of what could actually be helpful. Evidence that the individual called the police, or that they were serving the perpetrator with notice of the temporary protection order. Things that show that they are actually reaching out and trying to protect themselves and involve the system in reaching a resolution to the case, so that individuals understand that if they are full participants in the hearing, that is a way for them to evidence helpfulness.
Exactly.
Now, when we're talking about criminal case examples of evidence of helpfulness, that one seems to be a little easier. The list is on the PowerPoint, and I'm not going to read that all to you. But something as simple as just simply calling 911. Because, again, what you're trying to encourage is a safer community, right? And if you're trying to encourage immigrant victims to participate with the community in making their community safer, we want to encourage them to be helpful by actually participating in our community, by calling law enforcement, by talking to the prosecutors and giving a victim impact statement, by coming to court without fear of recrimination, and testifying and presenting evidence when they can. These are the kinds of things that a judge can use as evidence of helpfulness in determining whether or not to sign those certifications.
So going to the next kind of hypo, well, let's go back to our story. So while Clara's in the hospital, she met a victim advocate who worked with a legal services attorney, and after Clara's release from the hospital, she got her children back and helped Clara file a protection order. You heard Clara's protection order case and issued Clara a protection order against Eduardo. A week after the protection order was issued, Clara's legal aid attorney sends you a letter requesting that you sign a U visa certification. So we're going to do another poll, and this time we're going to ask, what evidence of helpfulness might you include on the certification form, given going back to that hypo and those facts of the case? So Danielle has posted the question, and we'll give you a few seconds, a little bit of time to answer the poll. Are the votes coming in, Danielle?
Votes are coming in, and I was just, I know it's probably annoying at this point, but don't forget to click that submit button after you make your answer selection, and we'll close that out here momentarily. The vast majority have chosen D, all of the above, with only one other selection being C. I'll go ahead and close that poll right now and share those results with you. You should see them on the right-hand side of your screen.
Wonderful, and that is true. It is all of the above. Any of the above would be sufficient for U visa certification in any of these cases. People think more about the criminal context, but it's important to remember that the protection order in and of itself is sufficient.
And for those of you who are starting to get a little queasy in your tummies because you're thinking, now wait a minute, don't I have some ethical considerations that are going to prohibit me from being able to do this? A couple of things. First of all, we are authorized under federal law to be able to do these certifications. And second of all, this is after the fact, right? So for those of you who would like to read the full Minnesota Judicial Ethics opinion, we have the site at the bottom of this slide. But basically it comes down to this. You are not vouching for anybody. You are providing information based upon the evidence that you either saw or was presented to you. It is not an issue of you authorizing the visa. It is about you providing information in the form of a certification to the feds. And I think I got back the ball, but I think it should have stayed with Leslie. But
okay. So, oh, do I have the, okay. Okay, so what's important to understand is picking up on Judge Gonzalez's last point. This process of a filing for a U visa takes a total of 18 years before lawful permanent residency. So victim files, there's a 4-year wait, and what's important to understand is that this is something that the Department of Homeland Security at every stage of the adjudication process is running fingerprint checks and background checks. And so they run that background check as soon as somebody files. They run it again at 4 years. They run it again 11 years later when a visa becomes available. They run it again 3 years later when the victim applies for lawful permanent residency. And then they run it again 5 years later when they can apply for citizenship. So it's a process where there's lots of fraud checks and protections built in, and it's a long process. But while this is happening, victims can live safely in the United States. They don't have a fear of deportation, and they can usually work in the United States. They can't travel back. So if somebody's in the process of getting a U visa and they say, Judge, we want to go home and visit grandma who's dying, they can't do that. Because if they do that, they could get stuck outside of the United States for a very long period of time. So it's important to realize that as well. So we're going to end this section on talking about the U visa form itself.
Yeah, and again, we are getting short on time, Leslie. But this is basically what it comes down to. So Part 6 of the certification, you can see where it says based upon the investigation of the facts. That's where you are talking about your findings, your findings of probable cause, whatever it is that is the information in front of you that can do that. And this is a great resource, and where can I find this, Leslie, if I want to talk about this?
This is available in the materials we're going to send you, and I'll put the web link in the chat in just a few moments.
Okay.
And this is written by the Department of Homeland Security, and it's a great Q&A tool. And there's a lot of different tools. There's also a judge's U visa certification toolkit, which we'll provide you as well.
And we hope we haven't completely driven you crazy with our alphabet soup, but that closes our conversations on the U visa. Again, realizing that what we're trying to do is just certifying helpfulness and trying to keep our communities safe. we're going to move on to Special Immigrant Juvenile Statuses. And this is, again, a place for us to understand what the congressional goals were. This is, in fact, a humanitarian protection statute. This is providing a lawful permanent residency path. This is not something new. This is something that goes back to 1990, and Congress was looking for a way to protect children who have been abused, abandoned, or neglected by at least one parent. That's what this is about. It was a way for Congress to say, wait a minute, we just don't have the talent in our federal judiciary to be able to look at these situations and figure out what's going on with kids. So instead of creating a whole new system of courts, the Congress said, well, why don't we just tap the resource we know? And the resource we know are state courts who are already experts in these areas. They're already, their expertise is there for us to use, and these decisions that they make every day is information that we can use to make our determinations. So basically what they've done is they've tapped into the expertise of state courts to take a look at the orders that we issue, determining child care, custody, placement, and we're already making those decisions about what's in the best interest of kids. So why not use that information to make the required findings? This is not asking you to do anything you don't already do. State courts make findings all the time on what is in the best interest of children, but in these particular SIJS kinds of findings, we just want you to think about a little bit outside the box as to what your normal boilerplate is. Right, Leslie?
Correct, and that this is really evidence. The adjudicators here, judges who issue state court findings, are making findings of fact, but not adjudicating the SIJS application itself. The Special Immigrant Juvenile Status application can only be adjudicated by the Department of Homeland Security.
But they cannot act unless we provide the information. And the information has to be based upon our state laws. So what we're doing is we're applying our state law to the facts as we see them regarding the care, custody, and placement of children. And we are looking as to whether or not, whether or not that child is in fact a victim of abuse and neglect, and whether or not it's not in the best interest of that child to return. In addition, we have to make a determination as to whether or not reunification of that child is not viable with a parent due to at least one parent having exercised or made abuse or abandonment or neglect towards that child. So let's think about that scenario that we have had previously. So thinking about, go ahead.
I'm so sorry to interrupt. I was just going to briefly remind everybody where the green check and the red X are located. Just underneath the video feed and the list of attendee names, you'll see the little hand icon. There's a green check mark and a red X, and that's the tool we'll be using for this slide. Thank you.
So the question becomes, are Lupe and Miguel qualify for special immigrant status based upon the scenario that we previously had? If you say true, use the green. If you say false, use the red.
And Danielle, can you see what the polling is saying?
Yep. It was off to a slower start, but people are making their selections now. We have 6 yeses and 3 nos. So the majority are selecting the green check mark. Even with the annotation arrow here, we have the majority selecting the green check mark. And that's where it's saying.
So the answer is actually false. Reason for that is that Lupe qualifies for special immigrant juvenile status because the abuser is her father. Miguel doesn't qualify because the abuser is his mother's boyfriend. Now, if Eduardo and Clara were married, then Miguel would qualify as a stepchild. And that's the main point. This covers children and stepchildren only. The abuser must be a parent or step-parent of the child in order to qualify for SIJ. Next slide, please.
So we sort of, no, you have the slides, Leslie. You have control.
Oh, okay, sorry.
That's okay. So we apologize for throwing that little curve at you, but it's really important to understand that when we're talking in a world where we have a lot of families in which we have parents living with significant others who are not the parent of the child, it's important that that distinction be clear.
Right, and that it's not that Miguel doesn't have a remedy, but his remedy is a U visa, which is that longer path to lawful permanent residency than SIJS, which is a much shorter, more direct way. And so all of the following children that you could see in your courts are potentially eligible for SIJS. Anytime there's a child who's abused, abandoned, or neglected, that abuse, abandonment, or neglect could have happened in the U.S. or the home country, and then they would have to be living with, and they could be living with a non-abusive parent or placed by you with a non-abusive parent with a guardian. So it'll be, you could see it in protection order and guardianship cases. It could be an adoption case, state foster care, or federal foster care. And that what's also important is that the statute, people get confused about this. The statute says juvenile court, but it could be actually any type of a court proceeding in your state in which the court has jurisdiction over a child. Somebody who's defined by your state law as a child in any type of proceeding.
And so, again, for those of us who do this work every single day, right, we're looking at the kinds of decisions that we normally make. And we make these decisions on a daily basis. Who's the custodian going to be? With whom is the child going to live? Whether or not the child is going to have to be in foster care, in the custody of the state, or a private agency. All of that are decisions that we make in all of these different kinds of proceedings, right? We don't necessarily just make decisions about where kids live in dependency court. We do it in a guardianship proceeding. We could do it in a termination of parental rights proceedings. Any court in which we have the jurisdiction to determine the custody and care of a child is one in which we can make these SIJS findings. But the important, go ahead, Leslie.
I'm sorry, Judge, we had a raised hand in the audience.
Okay.
If this is a good time for a question, I'm going to unmute Judge William Potter.
Hi, I had a question. The last time I looked at these SIJ cases, there was a split, it seemed to me, in the federal level and on the states as to whether or not that one parent abandonment or neglect actually applied. I have the issue with children coming in and they're living with one of their parents and they're alleging they've been abandoned by, typically it's a father that they've never known in their entire lives. Is that been resolved? Is that now clarified by statute or the courts?
Right. The clarification actually has come from the Department of Homeland Security Adjudicators Manual, in which they have confirmed, and the most courts have at the appellate levels and Supreme Court level have overruled those findings. As a matter of statute, where this comes from, Judge, is that, as typically unfortunately happens in immigration law, a statute will pass and the regulations are never updated. And so some of the courts were getting confused and trying to interpret old regulations that were overruled as still in place. And the Department of Homeland Security has resolved that issue definitively, in that a parent can be, based on the 2008 amendments to the Trafficking Victims Protection Act, are able to apply for SIJ while they're living with a protective parent.
Okay. All right. Thank you.
Thank you very much for that question, Judge Potter, because it is really important. Sometimes the court's decisions are not as up to date with the legislation of the provisions as Leslie has indicated. But so Leslie, if we wanted to stay ahead of that, where would you look?
Well, our funding through the State Justice Institute and the Kellogg Foundation is we just published for SJI a training manual for judges that has the most up-to-date information, and then we update the materials as the law evolves and makes them publicly available to all of you, so that we have a team of judges, of which Judge Gonzalez is one of them nationally, who provide judge-to-judge technical assistance on this. If you have questions, our website has a lot of the answers, and we can also provide additional answers for any new questions you have that arise.
Right. This is difficult for us to also understand, this concept of applying our state law. So, Leslie, why would I be applying state law if somebody is asking me to make a finding of whether or not there was abuse and neglect in, say, Guatemala?
Because the way the federal law is written, it is looking to state court judges to do what they do every day and to apply their state laws. So if what happened in Guatemala, because the child actually suffered that abuse, they're a victim of, of the criminal activity, they may have suffered trauma, they're in your court, could be a custody case, it could be a protection order case, it could be a child abuse case, and they want you to apply your child welfare laws and your best interest laws to that child to do what that child needs because they're now in your courtroom and in your community. And that the federal government decided that they wanted state court judges to apply state law to these adjudications.
And so sometimes it's difficult for us as judges to, as soon as somebody raises this issue, start thinking about international law and international work, and really it's about our own state court laws. So how you would establish jurisdiction is about state court law. The procedures and the notice requirements that are set forth in your state court are the ones that have to be complied with. And when you're looking at what is meant by abuse, abandonment, or neglect, the place to look for that is the definitions that are included in your statute. And not necessarily in the abuse and neglect section of your statutes, but it could include abuse, abandonment, and neglect definitions that may exist in your domestic violence statutes or in child endangerment and even forced marriage. It really is about the information that is available in your state and the tools that you have available in your state to protect children.
And what's important to understand is, for example, abandonment is defined under the UCCJEA in addition to the Uniform Child to Custody Jurisdiction Enforcement Act, in addition to whatever other definitions you might have in state law, and that's another example.
Exactly. So when you're doing the findings, the important thing is to make findings, right? To actually talk and describe about what it is that that parent did, what actions is it that that parent did that fit the state definition, your state law definitions of what it is you're trying to find, whether it's abuse, neglect, or abandonment. The actual facts are important inside your findings. And when you apply those facts to the circumstances of your case and make a determination of what's in the best interest of the child, the best interest law that exists in your state is what you have to go by. Whether your state requires you to use factors in your child welfare statutes, whether there is case law for your findings, or whether there is a separate statute under your family court custody awards. Wherever your best interest factors are in your state law, those are the ones that you have to look to apply. You do not have to go off to federal legislation to find it, because you're not going to find it there, and you're not going to go looking for what the law is in Guatemala or anywhere else. It is what is your state would consider to be the factors necessary for establishing the best interest.
Right, and then you cite your state statutes. You shouldn't be citing, you don't need to ever cite federal immigration law in your opinions here. You really want to cite your state statutes so that the adjudicators that are seeing this from 51 or 2 jurisdictions don't have to go look up what best interest is in your state, because it's you're reading your court order, they can see. And what's important here is you're doing your findings, and then the Department of Homeland Security does a set of its own adjudications, which again includes fingerprints and background checks and all kinds of things like that. And we just talked about this. This is it can be, as I said, one or both parents. Judge Gonzalez?
Oh. You know, if you're wondering why Leslie and I are having so much fun going back and forth, we have this little ball that goes between us as to who's got what slides, and this is the first time we've done this, and it's been quite humorous. That,
yeah, we're like, and if we change the slides on our page and don't have the ball, you don't see the change.
You know, one of those decisions that you have to make is whether or not the home country, returning back to the home country is not in the child's best interest. And this is another place where judges sort of get all in a tizzy about how they're making these choices. We make choices every day about whether or not it's appropriate to have a child in a home in your jurisdiction or whether there's a parent or a relative in, say, an adjoining state. So we make all sorts of choices about whether or not I have to place a child here in Wisconsin or whether I'm going to place with a parent or another custodian in Michigan or in California or in New York. So basically, this is not that different. It is about factual circumstances about that particular case that you have in front of you and why those facts would indicate that it is not in the best interest of that child to be placed back in their home country. So
for example, let's say you have a case in which you have a 14-year-old girl reunified with her mother, coming with a mother or an aunt or a grandmother to your court in any kind of a proceeding. And at home, she was living with her father and her grandmother, and her father sexually assaulted her in the grandmother's house, and the grandmother did nothing. And so in a case like that, you, under your state laws, would probably need to serve dad and mom, and, you know, or the parties would serve dad and mom, and maybe grandma would be brought in as well. And you might be looking at the mother in your jurisdiction or the aunt in your jurisdiction, the father who was the perpetrator of the sexual assault, and the grandmother who did nothing. And if you eliminate the father and the grandmother because of the abuse or failing to protect the child from the abuse, then there is no, it's not in the best interest to be with a custodian in the home country. The best interest is to be with a custodian, let's say, in Wisconsin. And then when you make that finding, it's not, you are essentially, that's the core part of the finding that you're making about why it's not in the child's best interest to be in the home country, because there's not, under your best interest laws, there's not a custodian, that's not the custodian you've chosen.
Right, and it does become about the custodian, not about the situation or the place that the custodian is located.
Exactly. Although, and sometimes they'll provide you evidence about that, and that might be useful additional facts, but the core is not what's happening in the home country. The core is the placement.
Right. So
we do have a raised, I'm sorry to interrupt again. We did have a raised hand, and I know we're running short on time. Did you want to take a question right now, Judge?
Go ahead.
Sure.
I'm going to unmute you. Judge, I think it's Cribben Acosta. You're unmuted now.
Judge Cribben?
And so the issue might be, she might be talking to us right now. She's on computer audio, and so I apologize, Judge. Your internal computer microphone may be muted. If you want to send me your question in the chat tool, I'll share it with our faculty. Thank you. Sorry for the interruption.
No problem. Should we continue then, or?
Oh, yes. Thank you, Judge. If when she sends in her message, I will politely interrupt again. Thank you.
All right. So, where were we?
From the next, yeah, there we are.
Yeah. All right, so in the order that you're finding, and you're making your findings based upon your state court that is not in the best interest of the child to reunify, there has to be some kind of factual basis upon which you are making your decision that reunification with the other parent is not viable. So you can't just make a legal conclusion here, just as you wouldn't be making a legal conclusion in your state court, in your regular state court findings without a requirement of SIJS statements, right? So you would need to include why it's not viable, the fact that there was a sexual assault by that parent, what it is in the facts that are before you and presented by you that make that reunification not viable. Anything you want to add to that, Leslie?
No, I can do that as part of the next slide.
Okay.
And what's important here is it explicitly doesn't require termination of parental rights. That's what the DHS manual, the Department of Homeland Security manual says on this. And that the viability of reunification doesn't even mean, so for example, you could have visitation, supervised visitation, let's say if you think about a typical domestic violence case here in the U.S. where the abuse occurred here, you could have supervised visitation, or there could be even some overnight visitation, but that's not the same as reunification. So the way I like to think about it is, let's say you had a contested divorce case or contested custody case, and you decided one parent is going to have full legal custody, and the other parent is going to have more limited visitation. If you're not envisioning that that's going to change anytime soon and there's no plans for it to change and that's an appealable order, that's sufficient to make the finding that at this point in time it's not viable that that person is going to be given back custody because you've made a determination otherwise.
And it's really important that it doesn't have to be a termination and you don't have to cut off all contact.
Exactly. And then when we think about viability and best interest, you apply best interest to this determination as well, and this is where your facts on viability will look at some of these factors, which are very familiar to you in the kinds of cases, kinds of determinations you're going to make in child abuse and domestic violence and sexual assault types of cases involving children. And you're going to look at these best interest factors and articulate why at this moment it's not viable to reunite with that family. What's also important as my last point on viability is that if the child is ever reunited with the abusive parent or the parent who abandoned them, et cetera, they lose access to SIJ. So it's not, if there's a change in the future, that could change too. I'm confused. Okay. So, and that the other thing that's important to understand is the earlier you can do these cases, the better. Some of them, because of the process of immigration, will come to you when children are older or towards the age of majority, and that that they need to receive the order before they turn the age of majority under your state law, or they lose access to SIJ. We talked about this. This is about the statutes and the regulations, and we'll go back to focusing on the best practice for court orders.
Yeah. So again, I don't know how many times I can say this without sounding like a broken record, but it is about making your factual findings. It's about articulating what it is about the facts that are presented in front of you that qualify this case as a case in which you're demonstrating that the child has been, in fact, abused, abandoned, or neglected, and why there is a requirement that there would be separation from a parent. It's very much like any kind of a contested custody case in which you're putting into the findings of fact and conclusions of law what it is why it is you're making a choice for one parent over the other. You don't want somebody else to fill in the space because they won't. They're not going to fill in the reasons behind the conclusions that you make. It's really important to articulate and to, as the slide suggests, connect the dots between this is my order and why did I make this order. What is it about this particular child and these particular parents that make it in the best interest of this child that you make the findings of abuse and neglect and that reunification is not viable.
So can I have the tool back, please? Thank you. I just want to go to conclude, because we're right at the end of the webinar. I want to focus and just tell you that this is a sampling of some of the trainings we do that our national team of judges and American University and Michigan State University are doing nationally, and I wanted to show you that there's SIJ-funded training materials. We'll be sending you a list of things, of materials, the directory that I talked about earlier. We have a Special Immigrant Juvenile Status bench card that or a bench book that we just published. There are bench cards in there so you can pull out if you're sitting in a custody case and track get pointers on how to do SIJS orders in a custody case, or in a protection order case, or in a delinquency or dependency case. And then this is our picture of our web library that you can go to for additional information on a variety of issues on legal issues related to immigrant children and immigrant crime victims, the directory of service providers. And this gives you, I'm going to conclude with a list of the kinds of topics that we cover for judges in training materials, which has to do with the forms of immigration relief, Violence Against Women Act confidentiality and how it affects discovery, public benefits access for parties who may be before the case, and language access from the courts. This is our public benefits map, so you can click on the state that you're in and look up easily whether the parties before you or a child before you may qualify for a certain public benefit. And the materials for this webinar will be available from the National Judicial College and from our website, and you can call us for technical assistance, and we can connect you with judicial experts around the country who can provide you assistance when you have further questions, and we can do additional legal research should you be asking questions we haven't already researched in the past. Back to you, Danielle.
Thank you both so much for that presentation, and I know we are right at the top of the hour, so I'm going to just offer a few final comments, and then I will close today's recording, and then we can unmute the phone lines to open it up for any questions or concerns, and then we also had 4 questions come in via the chat tool feature, so I'll be sure to address those here momentarily. But I did, before anybody departs us today, I just wanted to say thank you again and let you know that a post-course message will be sent out within 24 hours. This message will include a brief survey. Once you have provided your feedback in the survey, you will be able to download and print your certificate of attendance for today's webcast. And thank you all again for not only your attendance, but your active participation in today's presentation. I hope to see you in one of our online learning events soon. Please remember to check out www.judges.org to take a gander at our list of upcoming courses. And in closing, I, of course, want to thank our amazing faculty, Judge Gonzalez and Professor Orloff. Thank you again so much for your time, expertise, and for this informative presentation today. It was amazing. Thank you.